Good morning and welcome to this morning's legal webinar, our third in a series. I'm here with Stephen Matasich of the Brennan Mann Diamond firm. And Steve is a 28-year practitioner of law after graduating from Cleveland State's Marshall School of Law. And he is a partner in the law firm. And one of his areas of expertise is OSHA. And that is the topic for today's legal webinar, which is the OSHA Updates, which should be of interest to all of you. So without further ado, Steve, welcome.
Thanks, John, and thank you everyone who's tuning in here. We appreciate your time, and hopefully you'll get some useful information out here today. We do have a feature enabled that you can ask questions. What I'll probably do is, since our time is limited, if you do have questions, you can send them along, and then we'll try to address those at the end. So I thought I would just touch upon a few basic things. And again, since we have 30 minutes or so, rather than give you a very general, broad brush approach to things you've heard many times before, I wanted to move into a particular issue of interest to OSHA right now, and that's heat hazards, which applies in particular to the construction industry and the ways that they are stepping up enforcement of that, and is something that you as an employer in this industry can expect to see some greater activity this summer. So just to kick things off, we'll just start by looking at what the usual suspects are. These are still, year after year, the most commonly cited OSHA standards for the construction industry. We rarely see any of these supplanted with any additional. I mean, usually this is your top 7-8 list year after year. So these are the things: fall protection, ladders, scaffolding, personal protective equipment, all the items that go along with excavations, aerial lifts, and hazard communication. These are the things that are still main areas of great focus when you're out on the job site and in preparation for the work that you're doing, depending upon the type of job. So one thing I like to just remind companies of is all of the costs associated with a workplace injury and how workplace injury can impact your business. So naturally, you can have a workers' compensation claim, and those can last years. I've seen workers' comp claims open for decades, many decades sometimes.
Excuse me, would you represent employers on those claims
I
also?
do, yes,
Okay.
that is part of my practice,
Okay.
correct. And as part of a workers' compensation claim, you may have heard of a VSSR, which stands for Violation of Specific Safety Requirement. And that's basically like Ohio's state version of OSHA. And if you have an allowed workers' comp claim, you can request additional money in your comp claim through what's called a VSSR. So if you can show your employer violated a state safety regulation, OSHA, of course, is a federal agency, then you get extra money in your workers' compensation claim, and that can be expensive, particularly if you have a serious injury, somebody who's off work for a long period of time. That VSSR can be very expensive. And unlike workers' comp premiums, employers pay VSSR penalties directly out of their pocket, so it's potentially a substantial exposure. And of course, you can have an OSHA investigation resulting from a workplace accident. If you contest that citation, of course, there's litigation involved with that, which is a strain on your company. You can also be placed on OSHA's Severe Violator Enforcement Program list, which means they're going to step up inspections against your company, and they're going to pay particular attention to you. They're going to come out and do follow-up inspections and so forth.
Hey, Stephen, let me interject. So when or does possible personal liability come into play for violations and injury to employees, personal liability for officers or the owners of the company? When does...
Yeah, that's a great question, and that's a topic I have saved for the end here to go over real quickly, but OSHA is stepping
Sorry
up.
about that.
No, that's okay. is stepping up? It's a great question. Criminal prosecution, and we'll touch on that later, but usually if it involves a fatality and you have an owner or officer of the company who's directly responsible for safety conditions at the workplace, at the job site, then OSHA is going to refer this for potential criminal prosecution. I don't want to alarm you, but they are stepping this up, and I will cover that briefly at the end of our time here. So some of the others here are obvious to you: project delay, reputation. OSHA citations are a matter of public record. It could disqualify you from additional jobs in the future. Litigation, construction sites are no stranger to litigation for personal injury lawsuits, whether it's your own employee or the employee of another contractor who brings you into a case. And the National Safety Council estimates that employers spend directly and indirectly about $171 billion a year in connection with workplace injury. So it's as you might imagine, something that's very costly. So we're particularly a particular area of concern that you have at a construction site is OSHA's multi-employer citation policy. So this is just a brief reminder to keep these things in mind when you have multiple contractors on site. OSHA can cite your company if they feel you fall into any one of these four categories. The creating employer, so you're responsible or your employee is responsible for creating a hazardous condition or a violation of an OSHA standard, then OSHA will deem you as the creating employer. There's the exposing employer, where let's say another contractor leaves cover off a floor hole, but your employees are in the vicinity, working in close proximity to that. OSHA can cite you as the exposing employer. You didn't create the hazard, but your employees are exposed. There's also the correcting employer. So this is someone on the job site who's responsible for installing and maintaining safety equipment. And if there's a failure in that respect, OSHA can cite you as a correcting employer. And then lastly, there's the controlling employer. So if you have general project oversight responsibility, whether it's written in a contract or not, and you have the power to correct or to direct others to correct safety violations and you fail in that regard, then OSHA can cite as the controlling employer, and it can cite one employer whether they fall into one or more of these categories, and it can cite multiple employers for the same violation. So whenever you're out on a job site, you've got a heck of a lot on your mind, but from a safety standpoint, you'll want to keep this in mind that you can fall into any one of these categories, and so by keeping that in mind, you might help keep OSHA off your back. So then moving right ahead to heat hazard. So OSHA says that there's about 35 to 40 workplace fatalities annually due to heat stress. 50% of those occur the first day on the job, 70% the first week on the job, and it accounts for about 2,700 days annually away from work. Now, there's a general consensus, I guess you could say, that these numbers are substantially underreported because sometimes heat stress is not recognized. So let's say you have somebody on a work site who's dizzy and they're not, they're dropping something which is causing an injury, or they're operating equipment which causes an accident. Somebody has a heart attack on the job site. These things may be overlooked as being potentially connected to heat stress. And so OSHA is really ramping up its efforts in inspecting workplaces, and when you're in the construction industry, you're an easy target because your work is of course, predominantly outdoors. So OSHA from 2017 to 2021 did about 200 inspections for heat stress. And in 2022, OSHA came out with its National Emphasis Program, which provides a basis for OSHA to inspect workplaces. And in that national emphasis program, the agency directed all of its area offices to double the amount of their heat hazard inspections. So at least 400 heat inspections were required to take place in the year 2023, 2022, 2023, and I think we're going to see that number's still going up and that it's actually going to be quite a bit higher than 400 across the area offices.
So Stephen, for Northeast Ohio then, would this concern be obviously during the summer construction months for contractors, and would the controlling employer's safety coordinator on the project be responsible for monitoring the heat, when it starts to get, extremely hot at points, if it does?
Well, that's a good question. So if there's a controlling employer who has the power to correct or address these issues, and that entity can be responsible in OSHA's eyes, but as well as the contract or the employer whose employees are exposed to the heat has responsibility as well. So you can be on the hook either way. So one thing that's interesting in the National Emphasis Program is that compliance officers are directed to be vigilant about looking for potential heat stress situations whenever they're traveling. And naturally that means your industry, again, as usual, is a target of this language that's in the National Emphasis Program. So if you just have a compliance officer who's driving to a manufacturing facility, they drive by your place and they see that it's 90 degrees out, you got a lot of people working outside, they can park out in the street, get a hotel room across the street and camp out and look for any potential heat stress concerns, and if they have any, they can happen upon your work site and open up an investigation. So they're to be vigilant about that. And because of some additional developments very recently, which I'll mention here, you can expect that they're going to be doing this more and more. So there is no standard, OSHA standard, so they cite for heat stress under the general duty clause. I'm sure you've all heard of that. It's employers are required in general to keep their workplace free from recognized hazards which may cause death or serious physical harm. That's the catch-all category. And as early as 2016, NIOSH issued a heat stress standard of its own. If you haven't read it, I don't blame you. It's about 200 pages long, but if you're interested, it's really interesting. It goes through all the ways that heat affects the body, how your body parts respond to that, and why it creates a hazard. And then it, of course, goes through all the recommended safety processes for addressing it and mitigating it. In addition to that, in 2021, OSHA began the process for a permanent rule for heat stress. OSHA regulations take many years, sometimes decades it seems, to go from proposal to final rule to enactment. But this one, began in 2021. And in the interim, that's when OSHA issued their National Emphasis Program in 2022. And then just last month, ANSI, along with the American Society of Safety Professionals, issued their own standard. And as you know, OSHA often relies upon ANSI standards, incorporates them into their own standard. Now, they haven't done that here, and I don't suspect they will because OSHA already has its own rule in progress. But it's very timely. This just came out last month. And so they're getting pressure, OSHA, from industry to step up their efforts on heat stress investigations to implement the new rule. And in addition to that, also just last month, there was about a dozen or so state attorneys general who petitioned OSHA. This was led by the state of New York and Attorney General Letitia James. You may have seen her name in the news recently.
A little bit.
Yeah, so she headed that up, and about 10 or 11 other states joined her, and they sent a petition to OSHA to enact an emergency temporary standard. So you probably have heard of the ETS. This became kind of famous for COVID, and it gives OSHA basically authority in egregious situations where there's egregious harm that needs immediately remedied to issue an emergency temporary standard, which typically can last for only 6 months. And these states tried this last year for all indoor and outdoor employers, and OSHA rejected it. This time they've limited it to farm and construction industry. So again, you're the target. And I don't anticipate OSHA will issue an ETS. They may, but in light of the fact that they've got their own rule pending, hopefully we're not going to see that, because that's just it's going to make things a little bit difficult for many. So point is, the heat is on OSHA, so to speak, to pass a new rule, and they're getting pressure from the states, they're getting pressure from industry, they're getting pressure from union groups to do this. And so I think we're gonna, probably see more activity on that pending rule, as well as, without a doubt, stepped up investigations on the issue. So when it comes to OSHA inspections, when are they going to inspect? Well, the National Emphasis Program, and you can actually read this on OSHA's website. You can just go to the website, type in heat stress, and it'll bring up, you'll see a link to their National Emphasis Program, and I think it's around 100 pages. And it goes through all this, but it says the compliance officer shall, one, be vigilant. So whenever they're traveling, I already mentioned that, they're going to be looking for this. So they shall open an investigation. So let's say they're doing an inspection for something else, and they review your OSHA logs, which of course they always do, that's standard practice. And if they see anything in there that causes them any suspicion that there may have been a heat stress incident, injury, or illness, then they're required to expand the scope of their investigation to include heat stress. Under the same circumstances as if they're interviewing employees about something unrelated to heat stress and this is brought up, or if the compliance officer sees, well, these guys are working in high temperatures here, they're required by the National Emphasis Program to expand the scope of the investigation to include heat stress. So these are ways in which OSHA is being directed, their compliance officers, to really pay great attention to this. Any day that the National Weather Service issues a heat warning or an advisory, OSHA, each area office is required to do a program inspection. So they'll pick a work site or an employer just randomly off their NCAI list, and they will inspect that work site just because of the temperature that day. And that's a requirement, as well as in the NAP. As well as OSHA says that their compliance officers should automatically inquire about heat stress and what the employer is doing to mitigate it whenever they're doing any kind of inspection at all. So again, another opportunity for OSHA to look at your company for that. So before I touch real quickly on what OSHA would be looking for if they started asking you questions about it, what is hot? What's too hot? And when do you have to implement controls in order to mitigate the risk to your employees? Well, OSHA does what it often does, and it says, well, you got to consider a whole lot of things. And if you go to their website, they refer you to a whole bunch of different other publications and things to look at. But basically what they say is they actually give you a calculation you can make, which is a little bit absurd, but they would have you get what's called a wet ball globe thermometer, which measures not only temperature, it measures humidity, it measures radiant heat, and something else I can't recall, and then you come up with a number for that. You then evaluate how strenuous your employee's work is, you come up with a number for that. And then you have a factor where clothing, the kind of clothing they're wearing, is incorporated into the analysis, and then you come up with a factor, and then ultimately you come up with a number. But basically what it boils down to from OSHA's perspective is if they're working in temperatures that are 77 degrees or higher, and the work is what OSHA considers to be strenuous, then OSHA's expectation is you're going to take some steps to mitigate potential heat-related illness.
So Stephen, would you say that, somewhat pun intended, the red flag goes up when we get a heat warning in our area where your project is located, where you're working? Should that be a little trigger to pay attention to this?
Yeah, absolutely. And one of the things that you can do, you can get an app on your phone. It's by OSHA and I think ANSI or NIOSH, OSHA and NIOSH, and they have an app you can get on your phone that will give you a warning when there's a heat advisory. It'll tell you the temperature. You can click on a button. It'll tell you, okay, it's this temperature. Here are the recommendations we have for mitigating exposure. So it's actually perhaps a useful little app, but that's true. If there's a weather advisory or a weather warning due to heat or humidity, then that should definitely get your eyes open to doing some of the things to mitigate potential heat stress. So if OSHA does inquire of your company, they're going to want to know if you have a written program, whether you're monitoring temperatures, as John had just mentioned, which is important, whether there's access to cool water, access to shade, whether you're giving your folks hydration breaks, or at the very least making, again, cool water available. Climatization for new and returning workers, which I'll mention again in a minute, is really important. According to OSHA, they recommend a buddy system. So, hey, you and I are working side by side. John and I are working side by side. We're going to look out for each other. We're going to be trained in how to recognize symptoms of heat stress. So training is part of it as well, how to recognize it, how to report it, and what to do to mitigate it. So they'll want to know if you've provided any information to your employees and whether you've implemented any administrative controls. So that's things like work hours, job rotation. Again, that's very difficult in your industry. It's easier for general industry. But they'll go through these things, and then what they'll look at is, again, what are you doing to mitigate the risk? So are you assessing the risk by doing some of these things we just mentioned? Are you taking into consideration the clothing that your employees are wearing? If they're wearing face coverings for whatever reason because they want to, or because their job requires a respirator or a mask, that can increase your body heat and increase that person's risk to heat stress illness. Do you have signage up, warning of the symptoms? Just by way of example, I have a client in their restrooms that has a placard above all their restrooms, above the urinals, and I assume in the women's room too, where you can check the color of your urine, and you can look at it against the scale they have hanging on the wall there, and it tells you how hydrated you are, and depending upon the color, it tells you need to get hydrated. So these are just some of the things that employers do who have hot temperatures, in their work environment, whether it's indoor and outdoors, which the emphasis program applies to both.
Interesting.
So I mentioned the OSHA NIOSH app. You can check that out on your phone. Just do a search in the store, whatever phone you use, for OSHA heat app, and that'll pop up. So one big thing for OSHA is climatization. So if you have new employees who are coming to work into the heat for the first time, what OSHA and NIOSH, and this is based upon a lot of studies that's set forth in the NIOSH 2016 recommendations, is start the employee out at 20% of the full workday in the heat, and then each day thereafter you can increase it by 20%. So within 5 days, you can put the person into a full-time position working in the heat. If you have somebody who was working in the heat, is used to it, but they're out of work for a week or more, then they recommend, return them to their high heat shift, whatever they're doing that's in the heat, 50% the first day, and then you can increase it 10% each day thereafter. The science really does support that people who are new to working in heat, and that's what I had pointed out at the beginning, that 50% of heat injuries, illness, and deaths occur on the first day of working in the heat. So it's definitely important to consider acclimatization of your employees if they're not used to working outdoors, or if they're off work for a period of time and then need to return. So that kind of gives us a good wrap up on what OSHA is going to be looking for, some of the things to consider in the event OSHA opens an investigation at your place, or some things you can do to try to avoid that. John had brought up the question about personal liability, and I'll touch upon that right now. OSHA has always had the ability to assert or to recommend criminal prosecution for OSHA violations, and whenever there's a fatality at the work site, that automatically goes to the OSHA regional office, which for Ohio is Region 5, and that's in Chicago. And the regional office will review it to determine whether they want to pursue criminal prosecution. Now, I don't want to get anybody overly worried. It's usually reserved for the most egregious situations, and it's reserved for owners or directors who have direct control over safety issues at the workplace, and it's usually a recalcitrant company which is just really not taking safety seriously. So while on the whole they're still pretty rare, OSHA is stepping up its enforcement of criminal penalties. So these are the ways that criminal penalties can come into effect for willful violation causing employee death. The second one actually applies to government employees for providing advance notice of an inspection, or if you provide false statements on a document required by the Act. So if you have to have a written hazard communication program and you're falsifying information in that, then you can be criminally prosecuted for that, though I've never seen any case where that actually occurred.
Okay.
Yeah. So just real quick, what OSHA will look for to determine whether they want to do that is, have there been prior fatalities with this employer, or an instance of multiple fatalities? Is there a reckless disregard apparent for the safety of the employees? And those are just some of the things that the regional office will consider when determining whether they would want to go this route. Now, the penalties can be significant. $250,000 for individuals, up to $500,000 for business, as well as 6 months in prison. And OSHA criminal prosecutions, when they're done through OSHA, they are a misdemeanor. However, what OSHA is doing more and more, and you can Google this and you'll see plenty of cases pop up, is they'll refer cases to the local district attorneys or the U.S. Department of Justice, so either on a state or federal level for prosecution. And then there's the full availability of criminal penalties. Just by way of example, just last year in Colorado, there was an owner of a construction company who was prosecuted and convicted for felony manslaughter. This was an excavation, and excavation is a popular topic for criminal prosecutions, but the investigation showed that they were basically doing nothing. There were deteriorating conditions in the excavation that were obvious, that were ongoing for a period of time. And the owner of the small company basically did nothing about it. He was fined about $500,000 and sentenced to 3 years in prison. So that's just one of many examples you might come across if you were to Google this. But it just drives home the point of how OSHA is ramping up its efforts to hold employers accountable in ways that you may not be used to. And that includes heat illness, as well as their stepping up of penalties in this regard.
Well, the construction industry has, construction can be dangerous work.
Sure
Anytime
can,
it is. So that's why I don't want to say, construction has a target on its back for OSHA. It's just that many claims have arisen because of the nature of construction. So I think, we have many very good companies in the Builders Exchange, and I think they take safety seriously, but you have to know what's out there, how to comply.
Right.
So,
Yeah, it's dangerous work and you're outdoors, so it can make make you very susceptible to OSHA
Yeah.
sniffing around your project.
Well,
Sure.
Stephen is a national practitioner in OSHA because OSHA is a federal agency. So in one of these instances where his practice goes outside the state of Ohio. So you can keep that in mind and know where to get a hold of him here at Brennan Man Diamond. And been good partners with the BX here. So thank you very much.
Thank you, John. I appreciate it.